Hi everyone, and welcome back to Bowdie Shorts, making law make sense in 15 minutes or less. In this episode, we're looking at another one of the limited duty situations in negligence. This time it's pure psychiatric harm. And this is a topic that students often find intimidating because there seem to be a lot of special rules. The good news is that most of those rules can be organised around one key question. Is the claimant a primary victim or a secondary victim? If you can answer that question correctly, most of the marks follow naturally. By the end of this video, you'll be able to distinguish consequential psychiatric harm from pure psychiatric harm, identify primary and secondary victims, apply the different tests that govern each category, and understand how rescuers fit into the picture. So let's get into it. What is pure psychiatric harm? Well, psychiatric harm is the easiest way for us to look at this is to look at what it's not. So imagine a driver negligently knocks down a pedestrian. The pedestrian suffers a broken leg. As a result of the accident, they also develop anxiety, have nightmares, and have a medically diagnosed phobia of cars. None of that is pure psychiatric harm. Why, you might ask? Well, simply because it follows from a physical injury. The psychiatric effects are a consequence of the broken leg and the accident. This is called consequential psychiatric harm, and there are no special rules for consequential psychiatric harm. If the claimant can recover for the physical injury, they can recover for the psychiatric consequences too. Pure psychiatric harm is different. Pure psychiatric harm occurs where the claimant suffers psychiatric injury without suffering physical injury themselves. And this is where the special rules start to apply. So let's look at our first filter. So before we even discuss primary and secondary victims, there is an important stage we have to go through. The courts do not compensate every emotional reaction to a traumatic event. For pure psychiatric harm, the claimant generally needs to show a medically recognized psychiatric illness or a shock-induced physical condition such as miscarriage or heart attack. Simple grief, worry, distress, sadness, or anxiety will not normally be enough, and that point catches students out all the time. Fact that someone is genuinely upset does not automatically mean they have a legal claim. The law requires a recognized psychiatric condition or equivalent physical reaction caused by shock. So once we've got past the first hurdle here, the next question is, what type of victim are we actually dealing with? And there are two possibilities. A primary victim is someone directly involved in the incident. A secondary victim is someone who witnesses what happened to another person. So let's use a simple example. Sarah is riding a motorbike when a driver negligently crashes into her. Sarah escapes physical injury but develops a recognized psychiatric illness. A pedestrian, Jane, watches the collision from the pavement and develops a psychiatric illness after witnessing it. Sarah is a primary victim. Jane is a secondary victim. Why? Well, simply because Sarah was actually in danger, Jane was not. And that distinction drives everything else we're going to look through in this video. So let's start with looking at primary victims. And the law is relatively generous towards primary victims, with the leading principles coming from the case of Page and Smith. So for a primary victim, the court asks, was physical injury foreseeable? Now notice very carefully here, folks, what is the court actually asking? It's not asking whether psychiatric injury was foreseeable. It is asking if physical injury was foreseeable, then a duty of care will generally exist. And that is true even if the claimant ultimately suffers psychiatric injury rather than physical injury. So let's think back to Sarah and the motorbike. The defendant's driving clearly created a foreseeable risk of physical injury. Sarah happened to escape physical injury, but developed a recognized psychiatric illness instead. Because she was a primary victim and because physical injury was foreseeable, a duty of care is owed. So from an SQE perspective, the rules for primary victims are actually quite straightforward. Number one, is the claimant a primary victim? Number two, did they suffer recognised psychiatric harm? Number three, was physical injury foreseeable? If the answer to all three is yes, they usually are going to be in the position of being in a strong position. So who counts as a primary victim? Well, there are two ways someone can qualify. They may actually be in the zone of danger, or they can reasonably believe that they were in danger, and that second category is really important. A claimant does not necessarily have to suffer physical impact. They simply need to have been exposed to the risk of physical harm. So when analysing SQE questions, ask, was that claimant personally at risk? If the answer is yes, you should immediately start thinking about primary victim status. Let's move on to the more challenging one, secondary victims. So secondary victims face a much tougher test. These are people who witness injury to somebody else or fear for somebody else's safety. The key authority is the case of Alcock. Students often become overwhelmed by the details, but I will remember it this way. A secondary victim must satisfy 4 different control mechanisms. Think of them as trying to get through 4 different gates. The claimant must make their way through all of the 4 gates if they're going to be able to bring a claim. So gate 1 is foreseeability. Firstly, psychiatric harm must be foreseeable, but there's an important twist here. The court asks, would a person of ordinary fortitude in the claimant's position have suffered psychiatric injury? The claimant cannot rely solely on being unusually vulnerable themselves. The initial test is always based on the hypothetical ordinary person, and this is much stricter than the position for primary victims. So remember, primary victims only need foreseeable physical injury. Secondary victims actually need foreseeable psychiatric injury. Gate number 2, close tie of love and affection. The second gate requires a sufficiently close relationship with the immediate victim. Some relationships automatically receive a presumption of close ties: parent and child, husband and wife, fiancés. Other relationships may still qualify, but evidence will normally be needed. This means that simply witnessing a shocking event involving a stranger will usually not get you through gate number 2. The law requires a close personal connection. Gate 3 is proximity in time and space. The claimant must be present at the accident or its immediate aftermath. The law does not allow claims from people who learn about events days later. The claimant must be closely connected to what happened. And one reason students lose marks here is by treating immediate aftermath too broadly. Think minutes or hours, not days. The further removed the claimant is from the event, the weaker the argument becomes. We now finally come to gate 4, and the claimant must perceive the event using their own senses. Gate 4 test is proximity of perception. In simple terms, they must see it, hear it, or experience the immediate aftermath directly. So traditionally, hearing about events from another person has not been enough. Likewise, simply learning about the incident through later media coverage will usually fail as well. The law wants the claimant to have experienced the event directly. Let's now look at rescuers. And students often think rescuers automatically receive special treatment, and historically that idea existed. Today, however, rescuers are generally analysed using the same framework as everybody else. So the key question is still, were they a primary victim or a secondary victim? If the rescuer entered the zone of danger and faced a risk of physical injury, they are likely to be treated as a primary victim. If they merely witnessed horrific events without being personally endangered, they are likely to be treated as a secondary victim. So being a rescuer is not the magic answer. The real question remains whether they were exposed to danger themselves. Let's return now to breach causation and remoteness, and it's important to remember that this is still a negligence claim. Duty is only the first element. The claimant must still prove breach of duty, causation, and recoverable damage. And in reality, most psychiatric harm cases focus on duty because that's where the difficult arguments arise. One final point also concerns the eggshell skull rule. Suppose the defendant owes a duty to the claimant, suppose psychiatric injury was foreseeable, the claimant then suffers a much more severe psychiatric reaction because of some pre-existing vulnerability. Can the defendant argue that the reaction was unusually severe? Generally, no. The defendant must take the claimant as they find them. And once the duty hurdle has been crossed, the claimant can usually recover for the full extent of the psychiatric injury that has actually been suffered. So what's Bowdie's bottom line? Well, pure psychiatric harm is psychiatric injury suffered without physical injury. For any SQE question, start with 3 questions. First, has the claimant suffered a recognised psychiatric illness or shock-induced physical condition? Second, is the claimant a primary victim or a secondary victim? Third, which test applies? For primary victims, you're looking at recognised psychiatric harm and foreseeable physical injury. For secondary victims, you're looking at foreseeable psychiatric injury, close ties of love and affection, proximity in time and space, and proximity of perception. If you can classify the claimant correctly, the rest of the topic becomes much easier. If you ever get stuck, come back to the key distinction that sits at the centre of this entire area. Primary victims were in danger. Secondary victims witnessed danger. And that's the foundation for almost every psychiatric harm problem that you'll encounter. Thanks for watching this episode of Bowdie Shorts. We look forward to seeing you again soon.